Tyler, welcome, man. It has been a long time in the works.
Yeah. I haven't seen you in a long time, and you guys got some exciting stuff going on over here.
Yeah, absolutely. You too. So today we have Tyler Dunham on MFGMonkey. We have the infamous Nebraska back on the show. So we'll see what kind of value he adds today. Besides
just hanging out,
just big lug. Yeah, no. Tyler and I have been buddies for a long time. Yeah. It's like been 10 or 12 years, I think.
Say at least 10.
Through old Lair. I haven't even seen Lair for a while.
I still see him quite a bit. Yeah. Traveling, kiteboarding.
Yeah, absolutely. So, but no, welcome. It's exciting. This is our very first podcast in our own building, and it'll be a lot of fun. So I can't imagine a better person to have our first podcast in here. So thanks for coming.
Yeah, I like seeing all the random parts scattered around and asking questions, and it's a nice nerd manufacturing spot you got here.
Yeah, we all like to nerd it up. So we, Tyler comes to us. Tyler, you're a mechanical engineer, right?
Yep.
And a patent attorney. Mm-hmm. What a hell of a combination.
Yep.
Yeah. So why don't you, I guess with that, tell us a little bit more about yourself, and we'll get rolling.
Sure. My background really was in engineering. I spent most of my time doing through college doing internships with various different types of companies, doing everything from really large energy systems to a lot of research and development for automotive systems. And then I moved into more just consumer product development, which I think I enjoyed the most. Client comes in, they want to build a new product, they have ideas and things, but it's our job to flush them out, find something that will satisfy all their needs, that we can actually manufacture, that we can, ship to them and at a cost that they can actually afford to make a margin on. And so I think that was where I really cut my teeth in, manufacturing for a purpose and design for a purpose, design for manufacturing, all those kind of things, and learned, solid modeling and tooling and all those really good skills. But then went to law school, just wanted to expand myself really and wanted to keep learning. And I knew there was opportunity there for anyone who had a tech background to pair that with a law degree. There would be, some opportunities there. And so law school was a big change from engineering. I was a fish out of water for sure. But, like everything, you adapt and you learn and you get through it. And I learned a lot of great things in law school, even aside from things I would apply for engineering work or patent work. But clerked with a large IP firm here in Columbus for about 2 years through law school. Then I went there for about 8 years after law school, working for all different types of clients from all over the world, mostly doing patent prosecution work as well as some litigation and licensing. And then about 3.5 years ago, I left to start my own firm. So I've had my own firm, Dunham IP Law, for about 3.5 years now, a partner that works with me here in Columbus. And we represent clients not only on their patents, but all of their IP. So we do their trademarks and branding all over the world, as well as copyrights and software law, things like that, trade secrets, stuff like that. And so it's been good. I think I enjoy the constant learning that I have to do. Every client has a new machine or a new technology or a new set of problems, new set of competitors, and I like being able to learn and move and adapt to what their needs are. And just learning more, I find that I round myself out as an engineer, person, lawyer, as the more that I learn. And so I like being in private practice law because of the variety and the challenge. I think it's fun.
No, I think that's awesome. And I think the most important thing you left out is you being in a band, which always blew my mind when I first met you. Is like this dude's an engineer, he's an attorney, and he has a band on the weekends. I'm like, when do you sleep? It's like, I don't know, you're a machine. So it's always been interesting. And remind us what that band was called at that time.
Well, that band was probably Capital Sound.
That was Capital Sound.
Which was really cool 10-piece soul and funk and blues band.
Yeah.
The horn section and all that, really fun.
It was awesome.
It was awesome, yeah. It was a lot of fun. I was the band leader and everything, though, so it got to be a little too much, I think, to try and run a law firm as well as run a band and, all the other things I like to do. And so. And
you're still playing, right?
Yeah, I am. I mean, with COVID and everything, it's pretty much, nipped most performances in the bud, but we still, rehearse here or there. And then I'm in an original band now, too. And so we're writing songs and recording and all that, trying to make the most of this time, But
just have some fun.
Yeah. I think music's always going to be part of my life. It's just, it's been around forever, and I can probably play.
And your parents got you into it, and I remember you
Yep.
telling stories about, just you guys playing music as a family and
things
like that.
We still have a nice little family band every holiday. We get together and jam, and no song with more than 4 chords. That's like the max. You can't have any more than 4 chords in the song, but we'll pretty much play them and sing them, and it's great. I love it.
Yeah. Where most families get together and they eat and drink too much and argue, you guys are actually doing something productive. So,
well, nowadays you keep the arguments to a minimum when you're just, playing Creedence songs and Beatles songs. It's pretty hard to be upset with that.
Absolutely. But no, I think, with what you're doing, and Dan, Dan's been with me for, we were just talking about this yesterday, going on a year, coming out, not being involved in, the manufacturing industry at all. So he gets to see a lot of different things, which kind of complements what you get to see. And for that matter, what I get to see is that is the fun part, is nothing's ever the same. Every part is different. Every engineer is different that we deal with. Every project is different. And it is a lot of fun. And for us, we're kind of, we marry all these different people together, and what better to have, than a patent attorney, mechanical engineer that when we run across people, they can lean on. And, we've had that a couple times. I think Travis Snow has reached out to you here in the past. There might be a cool opportunity there and that. But tell us about, just start out with a story about one of the most challenging patent deals that you have worked on, either recently or, in the past.
Well, I think for me, I'm a mechanical engineer, and my bread and butter is, machines and electrical things, real tangible stuff. When patents get really challenging, it usually is when you get into the ones and zeros. And if that is really your magic sauce, is your software,
right?
That's getting more and more difficult to protect.
Right.
For a number of reasons. And a lot of it is just because, I can't just point to a figure, a drawing, and show you, here's why this is different from that. You're talking hundreds of thousands of lines, maybe millions of lines of code, and there's no way to easily kind of just show you and point to you why this is different. Whereas with machines and with circuits and sensors and systems, I can show you why this is different and why it's better. But I think in the world of software, it's very challenging to quickly be able to describe something that's very complex in terms that are general enough so that you won't be able to just walk around my patent.
Right.
So I think all the people who call me about apps, that's very, very challenging now. I won't say impossible, but it's very, very tough. And really software in general, even people who are doing some pretty revolutionary things like machine learning and others, it's very difficult to quickly describe something that complex and compare it with another very complex system and explain why in 2 or 3 pages or less why this is different or this is better in some way. And so I think those are the most challenging patents for me, probably, is anything that's mostly based on the software that's going on in there. And the physical parts and pieces are the same as everyone else's. It's just our software is different.
Yeah. No, and that is interesting, and it reminds me of a story, and I can't remember what the company's names were, and even if I did, we probably shouldn't name them, but it reminds me of a Columbus-based company that ended up working with a company out of Dallas, and Amazon loved their technology, and it was straight technology. It was all system-driven, but it gave them the opportunity logistically to move pieces and parts throughout a warehouse like no other company has ever been able to figure out. Amazon came in and posted up like they were very interested in buying their software. They spent 6, 7, 8 months at this little company helping develop all this, and then pulled out and went away and said, no, we're good. We figured we don't, we're not interested in it anymore.
Yeah.
They just stole their idea and developed it and repackaged it. And the Columbus-based company got involved because they were a logistic type company that deals in warehouses. And I think when his dad started it, they sold pieces and parts is how they started. And he got involved, ended up buying these guys out because it bankrupted this tiny little company. It was like 4 or 5 guys. And one of the first things that the small company wanted to do was patent their product. And the story that I told was, well, I don't really want to patent it because we have to reveal our secret sauce. He's like, so we'll just leave it alone. People are going to try and steal our idea, but they don't have access to what it actually is, the recipe of what it is. So they've just left it alone. What is your thought on I guess that plan with software?
Yeah, I think that's a very valid approach to those kinds of situations, and that's the line I think a lot of times you have to walk when you're deciding, okay, we've got something great here, and we want to protect it as best we can. What is the best strategy? And a lot of times it comes down to, I think, the reverse engineerability, if that's a word.
Right. It is today.
Yeah, we're going to make it one today. It comes down, I think, to how easily you can reverse engineer something.
Right.
And if it's pretty easy to take this thing and put it in front of some smart people and they can figure out how it's working, then you probably want to try and get that patent, even though it might be expensive and it might take you a while. And maybe there'll even be questions as to, how broad it is or how valid it is at the end. But once people know what you're doing, you can't really put that cat back in the bag.
Right.
And it's really tough to, I think, protect something once it gets out in the public unless you have a patent. Trade secret protection is your other route with those types of things. And, whether it's code or whether it's a chemical composition or whether it's a manufacturing process or something like that. Trade secrets, technically they last forever. They don't have any kind of limit to them. But they're a little more difficult to license because you don't really know exactly what you're licensing sometimes. I think you have to be very careful about how you treat them. So this is my biggest message to anybody who's really trying to maintain trade secrets at their facility. And that is really go over the top with your paperwork, and, your passwords and, restricting access to certain areas only for certain people, really make sure that when the day comes and the judge says, hey, I want to see all the things you've done to protect your trade secrets, you can show that, you can show it in a lot of different ways. If you can't, then the judge is going to say, you don't really have a trade secret here because you haven't protected it. Just because it is secret and the people don't happen to know about it doesn't necessarily mean it qualifies as a trade secret. You have to take these affirmative steps to protect them. And that's day one on a trade secret litigation. They're going to say, let's see what you've done to protect this. And if you can't support that, then the judge will probably say, I don't think this is a trade secret here, and you're not deserving of any protection. But even with trade secrets, when you take all those steps to protect them, if they get out, whether it's a nefarious former employee, whether it's, hackers, whatever it happens to be, once it's out, and everybody sees it. And there's really no way you can stop someone from copying it or using it unless you have a patent.
Right.
So kind of like that original company, even though they didn't do it, with a company like Amazon, they probably couldn't even go after them if they wanted to because they never took the approach to do anything, right?
I think somebody like Amazon is so big and powerful that even if that small company had a patent, they would probably tie them up in re-exams in the patent office, litigation, for years, and they just squeeze you. I mean, it's just there's a lot of bad stories out there of people who've tried to do business with Amazon or other large companies, and it seemed great, and everybody was nice, and at the end of the day, they were just brain draining you to get everything they could, and then they were going to build a competing product or a competing system, and it's tough because everyone wants to take a business opportunity when it's there, especially when someone who's knocking at the door has the kind of purse strings. I mean, people want to get in business with them for a lot of reasons, and it's very valid. And, as an entrepreneur, you just have to balance the risk with the possible reward.
Yeah.
And, look at your business and determine if this is really something you need, or if not, or, it's tough. And I think people in that position, it's difficult because if your technology isn't necessarily defensible or protectable by a patent, you're really relying on first to market kind of things and growth and, that kind of stuff to squeeze out competitors. And if your competitor is a Goliath, it's going to be really difficult.
Yeah, I don't think you could have an NDA powerful enough to protect you against a company like that.
Yeah.
I mean, they just have endless funds.
Yeah, yeah, and I tell people all the time, an NDA is just a contract, and you guys, I'm sure, know people break contracts all the time.
Yeah,
they sign it saying, "Oh, I'll do this for you, and I'll do this," and then it all goes out the door. And an NDA is no different, you know. And they'll argue in court that oh well, this happened and that happened, so we had to breach this NDA, and they'll have armies of lawyers that will stretch that case out for years and make it very difficult.
Yeah, and it is frustrating because we've had it happen to us where we sign a contract and you're going down one path and there's a hiccup and they pull. We've had a company pull out of a contract. And it's like, well, we have a contract. It's not worth the paper it's written on if you don't have the integrity to back it up. And I think a lot of times that's the bigger thing in business is the integrity behind the person that actually inked the paper. Yeah. Yeah. And if they don't have any integrity and they just don't do anything, especially as a small company, what are you going to do? Sue them? It's like, and then you ruin the relationship. You put I think you give your company a black eye because now they're like, oh, well, McMillan Co.'s litigious.
Oh, yeah.
Let's not do any business with them because if we have a hiccup, the first thing they're going to do is fire up their, attorney's hotline and go. So it's, it's a balance of, do we just try to work through it and ignore it and move on with our life and hope some good karma comes in the future? Or, it is an interesting game that you guys play for sure.
Going to court is the worst option for anyone, unless you're an Amazon. Yeah. If you're in Amazon, they want to play in court all the time, because they know they have the muscle to really win. But, I tell my clients all the time, great lawyers will keep you out of litigation, by doing good contracts, by, maybe we did sign a contract and then COVID or something hit and it's changed. Okay. Right. Let's just go back to the table and let's say, guys, what can we do? Let's renegotiate or whatever. Let's not throw the whole thing out. Right. Let's just, renegotiate. And if you continue to do that and you stay in touch with each other and you really do a good contract from the beginning, then that's going to help you, so much. And I always feel like kind of a wet blanket because, two people get together, they got a great idea, they want to start doing business together, and I'm like, hang on, what if he screws you? What if this happens? What if that happens? And the answer is, oh, Tyler, you're such a, naysayer, and you're always thinking of, the worst possible scenarios. And I'm just like, guys, let's just put it on paper. If it's never going to happen, then we'll put it on paper, and it's never even an issue. But if it does, you've got this eject button or you've got a clause in here that specifically kicks in.
Yeah, no, and I totally agree. And, we're getting ready to release a press release with Q-Grip that you and I were talking about out in the warehouse. And we did a big contract. And Larry, I've known him, Larry Cole, one of the owners. Victor's the founder of the company. He's a mechanical engineer, young dude in Victoria, BC, just a brainiac. And Larry and I, we were the ones that pushed the contract. And Victor was like, do we really need a contract? And Larry and I were both like, yes, we do, and if this is the only time that we ever look at it, awesome. And the next time that we need to look at the contract is something really went sideways. And the biggest thing I think with that is if either company decides to sell or, you get another partner in that they have a personality conflict. I mean, there's all kinds of things that could happen where, we've invested and they've invested so much money that you don't want somebody just to easily be able to walk away. Yeah.
Yeah. I think too many people feel like, well, this person I'm doing business with today is a really nice person, you know, and they have a track record of honesty and that's great. He could be fired next year and they bring in this shark, and guess what? He's not getting along with you. Well, you still have that contract there, so it's always important. And I mean, that's probably a lot of the worst situations I'm getting clients out of is because they never did any kind of contract and they just started charging ahead in the business. And the reason I think a lot of people do that is one, they don't want to feel like they're, insulting you by, putting all these, like, I would never not pay your royalties or I would never, not deliver on time. And I think that's a big mistake. And the other mistake too is thinking that person you're doing business with today will be the same person for years. They can change. Someone else can come in new. The board gets a new person on the board, and the board decides we want to slash costs. And who's this supplier? They're way too expensive. Get them out of here. Yeah. They don't care that you've been doing business for 20 years. They don't care. They're new. They want to make a name for themselves. They want to up profits however they can. So it's always important. And I also think on a final point on this is that I think people think contracts need to be more complicated than they need to. You know, even initially, just get something basic down. You know, just here's what I want to do. Here's what you want to do. Here's our plan. And hey, maybe we will, you know, supersede this with a more lengthy agreement later about details of international things or whatever. But for now, this is what we want, you know, and you just kind of walk through the process and get yourself there. A contract does not have to be a 50-page, you know, just a hammer.
Legalese in it.
Yeah.
And that is the difficult part is, you know, even with the contracts that I've reviewed, I mean, some of them are written and they're so hard to understand. It's like, does it really have to be like, it almost seems like the attorney is stretching their own ego by writing in this language that nobody understands. And then you read another contract and it's by an attorney that's more down to earth, and it gets the same point across. It's just as legally binding as the other contract, but everyone can understand it.
Yeah.
It's always funny to me, and it never fails. The contract that is written by the guy that you can't understand, or the girl or whatever, it's inevitable that they have the biggest ego in the room. You know, they're the guys walking in with the shades and the, you know, the $5,000 suit and that. It's like, really, like,
I'm going to put all these words in here that you don't even know what they are.
Right. You know, I'm Googling half of them, you know. It's like, all right, let's scrap this and start over. But, you know, I think they need to be in place. And, you know, one of the things we do agreements quite a bit, and we run into that all the time of, well, we have a good relationship. Do we really need this? And I'm like, I'm not worried about you.
Right.
You know, you own the company today. If you sell it to some asshole tomorrow that I don't know, that's who I'm worried about.
Yep. Or he takes on a new investor, and this investor is a real prick. You know?
Yeah.
I mean,
and it is, and I think that's a good negotiation or just communication style. It's like, well, it's really not that you and I are worried about each other. It's it's like being married. You're not worried about each other. It's the other person that you don't know about yet. You know, it's like, but one of the things that you wanted to talk about, and a lot of the patent things are way out of my, I can't even ask educated questions. Maybe Dan can, but you wanted to talk about patents versus trade secrets. So, talk to us a little bit more about that. Like, what does that really mean?
Yeah. I kind of started to scratch at that a little bit before, but it's something that comes up a lot with clients, and I thought would be interesting to talk about today, especially in the manufacturing world. And really, it just comes down to the way that you treat that technology. But let me just back up a little bit. The first step when we're looking at these things really is, are we going the trade secret route or are we going the patent route? You need to make a definitive decision on it because number one, like we said, you need to implement policies, procedures, paper that's going to back up your trade secrets. And number two, if you're going to file patents, you need to file them. So I don't know how many people know this, but there is a sort of clock that starts running that you need to file your patent applications. And it usually starts as soon as you use or sell or offer to sell the device in public in some way. Okay. So research, prototyping, all those kind of things, that's not really going to start your clock. But when you go out and you start offering it for sale, when you go out and you start, advertising it or just go to a trade show and show it to people, a lot of people would say your clock has started. And that basically gives you 12 months to file your application in the U.S. Patent Office. So I think that's number one. A lot of issue that people run into is they kind of delay, and understandably so. They don't want to put money into a product that they aren't sure is going to really sell. Right. And so they want to wait and kind of see what's the feedback. What do my customers think? What do the people think about this? And unfortunately, if you wait too long, then you've lost it. Right. And that is actually an even harsher penalty on the international stage. So in the USPTO, we have this 1-year grace period. Okay. Foreign patent offices are not as nice. They're called absolute novelty patent offices, and they basically say, hey, anything you've done in the public before filing, you don't get a 1-year grace period. It's invalidating your patent internationally. So for clients who are only playing in the USPTO, they have still that 1-year grace period. But for my clients who I know are going to try and pursue a patent internationally or somewhere else, then I know that we have to get this thing filed before ever you go with it publicly. So that's kind of the big thing too, is we have to make that decision before we go public. Right. And I think the decision for the most part, like we were talking about, comes down to whether or not the product can be reverse engineered. That's usually the way.
Right.
So, your typical like Coca-Cola and things like that, the chemistry for those kind of things have been held as a trade secret for probably over 100 years now and may stay that way forever. Whereas if they would have patented it, it would have ran out a long time ago. So those are always, that's, I think, the biggest thing that you have to think about when it comes to that. And there's certain technologies that are just really ripe for patenting, and that would be physical things, whereas other technologies that are, based on software, based on chemistry, or maybe even based on some kind of natural sciences might not be the best for patent protection, might be better for trade secret protection.
So with a trade secret, you don't have to disclose what the recipe is or your secret sauce of whatever your trade secret is?
A trade secret, begins as soon as you have created it and you have some kind of policies and procedures and paper to keep it secret.
Right.
You would never really go around barking about, hey, we have trade secrets, I think the way you would see that in public would be say, we have proprietary technology on blah, blah, blah.
Okay.
And that's kind of, commercial speak for, we have trade secrets that protect these things. But really the word trade secret is really just a legal construct that comes up when you go to sue someone for taking something, stealing something, using something that they don't have permission to use. And like I was saying before, that's going to be the first step, is going to be proving that this actually is a trade secret. Right. And, one, you're going to have to show that no one else really has this. It truly has to be secret. If lots of other people have essentially the same piece of code or the same, kind of chemical composition, then it's really not a trade secret because everybody kind of has it. And we all have a general idea of what you're doing there. But if it really isn't known and derives value from not being known, then it would be considered a trade secret, provided you can prove all of the steps that you took to keep it secret. And I think a lot of times we might think that that's easier to do than it actually is. It does take some diligence. And when you're going through your day-to-day, you have your high priority items that you have to deliver for customers, and then you have a bunch of paperwork that lawyers and accountants and other people tell you need to do. But it's like, look, I got to keep the lights on. I got to fill these 2 contracts and send out these invoices, and the lawyers and the accountants can wait until tomorrow. And so I understand why it's very easy to just put that stuff on the back burner, and and then lo and behold, it doesn't really become an issue until someone steals it, or you want to go to court. Yeah. And the lawyer says, well, what do you have, to show that you've protected this? So I try to really work with my clients on that because it's subtle. It's not as obvious as patents and some of those other things. And so, beginning from your employee intake forms, to make sure that they're signing things that says, look, I know I'm going to learn things here that are secret, and there's value to that, and I'm agreeing that I'm going to hold that stuff secret, and all of those kinds of things, making sure that there's enough paper to back up the fact that, yes, we think this is secret. We've done everything we can to try to keep it secret, and it's just an important thing. And so I think that that's something that clients, it seems like they don't realize that process has to start years ago. They always want to start the process when we're about to file a lawsuit or something like that. And if the judge finds out that you just started that a week before we filed the lawsuit, he's going to say it was purely for litigation. You weren't really protecting it. Right. So,
no, that is interesting to me, because I guess I never even thought about trade secret versus a patent. And with the trade secret, it's like, well, it's a secret. Who am I going to tell that I have a secret to? And that is interesting. Of if you have a recipe, whatever KFC's, their secret sauce of their, I don't know, the crunchy
spices
stuff,
or something.
The spices, it's like, how do you protect that? Because you have all these employees mixing it, and you're ordering, all the ingredients from all these different vendors, and you could really just pick it apart and know exactly how much pepper's in it or how much flour's in it or whatever.
Yeah.
But yeah, that is very, very interesting. That I never would have thought of. So, And the other thing that you were wanting to talk about was design patents versus utility patent, which I know nothing about either. So, I mean, I guess I could take the context and run with it and
you probably, I would think if we put a gun to your head, you could come up with a pretty good, you know, description of the two, and you'd probably be pretty close.
Right.
You'd probably be pretty close.
But yeah, explain to us the difference of those.
Yeah, so I wanted to talk about it because I thought, you know, it's something that comes up a lot. And, you know, even for sophisticated people, I think there's a line between those two, and it's hard to draw it sometimes.
Yeah.
But, you know, your utility patent is your traditional patent, and it's going to have a set of figures and then a written description that describes everything that's going on in the figures. And then it's going to have these lengthy run-on sentences at the end of the patent, which we call claims, which is basically what we are describing as our invention. This is what we have created that no one else has created. And then when you go to determine the infringement of that patent, you're going to look at those claims and see if those claims are found in infringing devices. It's really for something that has physical pieces in it that we can't find anywhere in the prior art, and that it's in a combination that we can't really find in the prior art. A design patent really is going to go more after the aesthetics of how something looks. And it's not really going to be focused on, hey, we're the first person that's ever made a bottle opener. We're not saying that. We're the first person that's made a bottle opener that looks like an alligator or looks like a whatever, you know.
I gotcha.
And the other really classic example that I love, and you guys would probably remember this, is the old Sports Illustrated football phone. Do you remember when you would, like, if you subscribed to Sports Illustrated, you would get this phone that, like, looked like a football?
Dan, you got to have one of those.
Not anymore, but I definitely did.
Somebody's got one probably in a sweet collection of really cool memorabilia, but I just always remembered it as a kid, and it came up like a million times during the patent bar and everything as just a great example, because there's no reason functionally that phone should look like a football. You know, it doesn't add to reception or comfort in the handset or anything like that. It's purely just, hey, this looks cool. No one else has done that, so we want to get a patent on that. So for a long time, I think probably before my time, more in like the 80s and very early 90s, a lot of us viewed design patents as not really that powerful, because I would just change a little feature. You know, I would change this element, or in the alligator bottle opener, you know, I would make his tail a little different, or I would do this, and I would say, well, I avoided your patent. And then people started really filing a lot of design patents on what we would consider more, you know, industrial products. Everything from like dock loaders to, you know, the iPhone and the iPad. Those were huge ones because it was very, very simple devices. I mean, you're talking about a square with a little circle button on it.
Right.
And it was like, how in the world can you protect that?
Right.
And what kind of real value is there in that? And, you know, then Apple and Samsung sued each other for, you know, $1 billion. I think Samsung wound up paying like $700 million or something. But I think it was eye-opening for a lot of us in that, you know, maybe one of the most valuable patents in the whole Apple portfolio wasn't, you know, this amazing encryption technology and all the other stuff that's inside of it. It was just the way that it looked. Yeah. You know, no one had a phone that, you know, was so clean and crisp. And so, you know, that was a great eye-opener, I think, for a lot of people, that those patents are more powerful than we thought.
Right.
And they should be used as such. And so if you have a product that maybe is a combination of other stuff that other people have done before, and it's not necessarily bringing some new huge technological feature to the table, but it looks a certain way, and people like the way it looks, you know? Yeah. Design patents are a great route for that. The nice thing with design patents is they're much less expensive than utility patents, both to draft and get them. They can be, you can file multiple of them on the same product with sort of different features included in each one, so that you sort of set up a minefield for someone to try, and if they're trying to step around this patent, well, they stepped right into this one.
Gotcha.
So it's very common to file multiple design patents on one product, even though, you know, your commercial version looks only one way, but we have 3-4 different patents that all protect different kind of elements of it, you know. And what's really nice about them too is proving infringement seems to be much easier, because I basically just show you a picture. Here's our thing, and here's their thing, you know. Right. So when I'm in front of a jury, it's way easier to kind of tell the story, you know, like, hey, we built this great thing. They copied us, you know, they should have to pay for that copying. Right. In the utility world, you know, I have this very long sentence that might be anywhere from 30 to 100 words long, busted up into segments, you know, and each word has its own meaning, you know. I mean, if I say a clamp that is perpendicular to this surface, well, what does a clamp mean? You know, is it like permanent clamp or temporary clamp, or just two surfaces that touch? Is that a clamp? You know, so you have to fight all these battles in utility patents that make the litigation extremely expensive and very questionable, because you can't really look at a device and just say, oh yeah, well that infringes. It's very hard, you know, and I spend a lot of time doing opinions for people on whether or not I think something is infringing or not by doing that analysis. And design patents are much, much faster, much easier. So I think that I just think they've been overlooked for a long time, and it seems like more and more, especially for your small company startups, to just get yourself a design patent or two to start building that portfolio. And if you have somebody that likes a product or whatever, you can license that to them and you do it. Whereas utility patents, you know, it could be a 3-4 year battle to get it. Then there could be questions at the end as to exactly what does it cover. And so I just think that sometimes for resource purposes, you only have a certain amount of money to spend. And my mantra with clients a lot is, you know, let's get every ounce of every dollar that we can, you know, in protection. Right. And, you know, if we're going to spend a few $1,000s, let's get the biggest bang for our buck that we can and move on to the next problem that you have, you know, in your company. So I never want patents to stick in the way of what my clients are doing. I want them to flow with their business. Right. I get very, very nervous when someone's business model is basically, we're going to get all these patents and then we're going to like license them to people or whatever. That's a very, very risky, extremely dangerous business model. What you really need to do is build something people love and then have a great IP portfolio that follows along with what you're designing and building. But trying to like find a space and then say, well, we're going to get all the IP on it and then kind of shake everybody down and try to get license fees from people. That's a difficult business.
It seems stressful.
Yeah.
I mean, just to try and go down that path, like you just are opening yourself up for lifelong journey in court, I think.
It's a lawyer's dream probably for companies like that, you know, and I would get a lot of work out of it, but I just, you know, I always put myself in my client's shoes and I just always think, would I do that? You know, and even as a lawyer, it's sort of, I'd rather low hanging fruit in my business. You know, I'd rather know there's a goal to be achieved here. I'm going to get it. And then I'm out. Right. That business model is more designed for shooting for the moon. If we hit it, man, we're going to hit it huge. Or we're going to go in a huge hole with a bunch of lawyer fees and, you know, all these other things. And really nothing at the end of the day to show for it. You know, like you don't, at least if you're running a business and making a product, if your patent fails or it falls apart or you lose in litigation, that's okay. You know, we'll go make another product for someone else. We'll keep doing what we do to make money. But if everything is based on a patent portfolio that could rise and fall depending on whether Amazon wants to attack it or whatever, it's much more difficult to defend. And I would have trouble sleeping at night. You know, thinking that I'm going to make some money in that business.
Well, we've had some customers that have come to us with things that they want to sell, and I've asked the question, you know, is this patented? And they're like, no, and we don't plan on it. And I'm like, well, okay. I'm like, so what's your business plan behind this? You know, for me, if I want to put my money into it to have it manufactured and sell it to them, you know, we dig pretty deep into, you know, what their business plan is, you know, and their financials and all those fun things. But the one thing that I've always loved to hear the most is that we just want to create such a rock solid brand that we know somebody's going to rip this off at some point. And we just want to be the Kleenex of whatever this is. So it's always referred to as a Kleenex, regardless of who makes it.
Yeah.
And I'm like, okay, that sounds legit to me. I mean, and it sounds like a solid business model that I can get behind, is they want to be the standard in that space, regardless of who rips it off. Yeah. And they're like, we just don't have the energy. We want to sell so many of these out of the gate and create such a brand and such customer service that we're always the standard. Yeah. Yeah. And it makes a lot of sense to me. And then at that point, then they can, you know, go down the path of design patent versus utility patent or, you know, whatnot. So I don't know. It seems a lot of those things seem very, very interesting to me. What is your thought on that? Would you persuade somebody differently if they had something that was easily copyable, I guess, is that a word? Copyable?
It probably sounds better than reverse engineerable, but probably makes more sense. Well, I'm really glad you brought that up, because trademarks are, you know, a huge part. You know, I mean, we've been talking patents mostly because we talk manufacturing and everything here, but you know, trademarks is really the first rung of protection for your business. And I don't care if you know, are a brewery or a little local Italian restaurant, or you're doing machine learning automated robots. You know, everyone needs to establish, this is our brand, you know, and this is what we've created our name on. And I've seen clients have so much success it seems like so much more success exiting a company, selling a company, or licensing out any kind of technology when it includes a good brand behind it, you know, that was well thought out, and it was carried through, consistent through things they did, and they had a culture that was very good, and, you know, everything was just very nice. And when that big fish came in, look, they liked their design patent, and that's nice and all, but what they really wanted was that trademark. You know, what they really wanted was that brand, because that was what connected with people.
Right.
And that was what really, you know, kind of took off. And, you know, trademarks are very inexpensive compared to utility patents, certainly, and, you know, still inexpensive compared to design patents.
Right.
And the value that they can turn around, I mean, it could be millions of dollars in your corporate evaluation to have a couple good registered trademarks that are valid. Right. And, you know, so I think that I wouldn't feel too nervous, you know, when someone comes saying, like, we know someone's going to rip this off, we're just teeing this up literally for an exit. I actually don't think that's a terrible business strategy, because in my personal opinion, and you guys, this would be a good question I'd love to ask you too, is that the big companies right now really don't want to innovate. They want to just sit back and let other people dabble in the laboratory and then gobble them up once they've shown some traction, and they've shown that, oh my gosh, they got 1 million freaking likes, you know, or 1 million like people on their Facebook page or whatever. This is real, you know, let's go have a meeting with them and see what we can do. And so it's almost like you built the whole business up just to be this enticing carrot for these larger companies, because it just seems like they don't want to quite take as many risks. They'd rather the small companies do that. And then if they're successful, they'll come in and
sure,
and make an offer to purchase. So I really don't think it's terrible. I just always tell them that, you know, because I've sat across from lawyers debating how much a company is worth and all this kind of stuff, and they're always going to push back and say, well, you don't have any registrations, you don't have any patents, you don't have, you know, you don't have things to really protect what you're going to sell me when you sell me this business. I'm really just buying your, you know, your operations and your inventory and these kinds of things. We want to have paper that shows, like, I'm licensing, you're getting this patent, you're getting this trademark registration, you know, you're getting these real things. And that's how I can then push back on an evaluation when they're like, well, we think this company's barely $2 million and you guys think it's 20 million. The way we push back on that is the value of this IP and stuff. And so that's the only thing I just always tell them. But that can be done through trademarks and design patents. You know, it doesn't have to be done through $100,000 in utility patents. Right.
Well, and I think that kind of leads us into the third thing that you wanted to talk about was patentable subject matter. I mean, that's an attorney term right there. Patentable subject matter. I don't think that's ever quite flowed out of my mouth before, but it, you know, it makes sense, and that is like, okay, what does make sense to patent, right?
Yeah, well, I should have phrased the question a little better now that, you know, you mentioned that. That really was like teed up for lawyers.
I mean, you threw the softball, I just had to smash it. So
it really should be titled, "What can you patent?" ?
Right.
That really should be the question. And forever the answer was you can patent pretty much anything except for natural occurring things. So if you go and dig in your backyard and you find this amazing titanium alloy that's just incredible, well, you can't patent that. You didn't make that. You just found it. You can't patent mathematical formulas and physics and things like that. You know, like formulas in mathematics are not patentable. It's not a thing. You know, it's just a theory or an equation that describes it. You can patent a machine that works on a formula or works on an algorithm or something like that. That's perfectly fine, but not the algorithm itself, or not the actual, mathematical equation itself.
Okay,
like you can't patent that. So that was really the answer forever. And we patented, you know, pretty much anything under the sun, and especially on the software side of things. And that was really starting to get a little carried away when people were patenting everything from tax prep method software, where you would kind of put different tax, you know, things into a box. I think H&R Block and all those guys, basically.
Sure.
How do I minimize my tax strategy? Well, they built these very sophisticated algorithms and, you know, really great piece of software that'll tell you real quick, oh man, you should be filing as a single with this over here. And so they were getting those patents. There was guys getting patents on hedge fund or hedging investments, you know, where there was an equation that would kind of calculate the risk in this investment and then the risk in this investment. I'm going to put some money in here. And for years, that was fine until a few years ago. We had a case called Bilski, I think. And basically the Supreme Court took up one of these hedging algorithms. And they said, hey, this is just what investors do. You know, this is just what good savvy people, you know, you're basically trying to patent being an investor, you know, and like, So if my computer walks through these steps, then I infringe on your patent. And so the Supreme Court really just made a very huge knee-jerk reaction and basically tried to draw a line in the sand and saying these types of things are just not even patentable subject matter anymore.
Wow.
And the issue that created was, well, what the heck? What do you mean? I mean, is it just these kind of like investment things, or does it include, blockchain and like legit technology that is new and very useful and should satisfy all the requirements of the patent office? So it's really created a lot of problems in that world. And I think that was why earlier I was saying there's some of the hardest patents to write.
Is that still in court?
The Bilski case is long done.
It's long gone. Okay.
But we've had a string of, my goodness, we've had probably 20 cases at least since then that have come up to the court over and over and saying, okay, well, what about this one? Is this okay? Is this one okay? Is this one okay? And it's just been a haphazard, sometimes the court will say yes. I mean, you got to remember, these are Supreme Court justices. They have no tech background. They couldn't, I mean, you try to explain blockchain to them, they have absolutely no idea what you're talking about. So it's not in the proper venue. It should be done in some kind of special, area of Congress full of scientists and engineers and entrepreneurs and corporate people who can say, look, this is what we should be protecting and this is what we shouldn't be. But unfortunately, we aren't getting much done at all on a congressional level, and this is a very complicated problem that is just getting pushed to the bottom of the pile, I think. But what has really made it bad is the blockchain. While that is still patentable, it's starting to become trickier and trickier. The machine learning, which is amazing stuff and is going to revolutionize our manufacturing and automation and stuff, trickier and trickier to patent, very difficult. But more than that is that the Supreme Court, when they made this initial holding, they listed out all these different things that they now view as not patentable subject matter. You can't get patents on these anymore. And one of them was naturally occurring things. And that was kind of always how it was, and that's fine from I dug this up in my backyard or I discovered this or whatever and I can't patent this. But what it's now carried into is, gene sequencing and bio types of things where, people are patenting the idea that, well, if I see this certain marker in your DNA stream, then I know that you are, susceptible to breast cancer. I know that you are susceptible to, I know you've got corona because of this little weird thing in your DNA right now. Well, there's a lot of questions as to whether or not you can patent any of those diagnostics anymore because of the holdings of the Supreme Court, who basically have said that things that occur naturally in nature are not patentable. And they have struck down, I think there was a famous where they had cloned an animal, and they were basically saying that this clone was not patentable. The technology used to clone this animal is not patentable because it's just an animal, it's just a goat, there's nothing, it's a goat, but it wasn't a naturally occurring goat because it had the exact same DNA as the one next to it, which doesn't happen even in siblings, or I think even exact twins have different DNA.
Exactly. Yep.
So it was, it's been a real issue, I think, for people in the medical diagnostics community, and that could have, I've heard murmurings that it could have something to do with our issues with testing in this country, is that we can't really get great people to solve this problem because they aren't convinced if they put $400 million into finding a solution, they'll have the protection. You know, they're a little worried that either the government's going to take it and just give it out for free or, various other things. So like any investor who's putting money into these companies wants some kind of guarantee on their return or some protection, you know, for what they've got. And that's created a lot of issues in the bio world. And I think we're due for a lot of amazing inventions in the bio world, whether you're, you see them 3D printing live tissue, you see like all these incredible things happening now, which is this weird blend of, additive technologies plus, bio things. And the future is bright for that stuff. But the question is whether or not investors will really back it if you can't patent it.
Sure. No, and that's, I had no idea anything about that. And it's actually kind of sad, looking from the outside in where, there are, being that the case, nobody's going to, it's going to take somebody very, very, very passionate about an issue to sink money into that, to come up with a solution, because everyone does everything for a return. Yeah. And if people are, I would think once that law, there's a decision made on it, like you said, it's either going to open up the floodgates and everyone that has these ideas that are locked in their basement somewhere coming up with new solutions that are going to finally come forth with them, or it's just going to be lost forever if we don't make a decision. Where do you think that where we are in that decision? Do you have any idea?
Well, I mean, it seems like the ultimate answer is going to be some kind of act of Congress, when we all sit down and decide.
Sure.
These will be it.
But I mean, is it even an open discussion with Congress right now? Is it active?
Oh, yeah.
Very, very active.
Absolutely.
Yeah.
Yeah.
So it's going to take probably a big pharma company or somebody with a tremendous amount of money to really push that to come to a decision.
Yeah. Absolutely.
And try and lead that in the direction that they want it to. I mean, the obvious answer is, if it's not an act and you're creating a process with the algorithm, then you can patent the process, right? Mm-hmm. It would be just like, to dumb it down to my level, if you are using an algorithm to get a widget from this corner of the warehouse to this corner of the warehouse, and you're using math to guide it, the math itself isn't patentable, but the process and the machinery to get to the end solution is patentable, correct?
Yeah.
So what's the difference in that situation? Even though it's way more complicated, you're using math and you're using blockchains and you're using technology to get from point A to point B. You don't have a cure to having a cure. I guess I don't understand the difference of why that wouldn't be patentable. You can't patent the goat. I understand that. You can't patent the goat. The goat's off limits.
Right.
But to get the goat from, goat A to goat A, you have two A goats, you can patent the process, I would think. I mean, that would make sense.
I think in the cloning process, yes, you're absolutely right. Because, a cloning process does not exist in the real world.
Right.
But, this is getting a little into the weeds, but process patents are different than product patents.
Okay.
So they're enforced in different ways and things like that. We usually like product patents because that's what's out in the public. Mm-hmm. And so I can see if you're infringing on my client's patent and we can do something about it. When my clients have process patents, it can be tricky because I need to see I need to see your factory. I need to see your process. I need to see your cloning process. I need to see the steps that you took and how much did you inject here and things like that. And that's very hard to get unless I sue you. And I do discovery, and then I can see all that stuff. And so I don't want to be going into lawsuits with my fingers crossed that, boy, I hope there's evidence there that they infringe.
Sure.
So I think it comes down to the difference between products and process in that example.
Yeah.
And when you're talking about a system that uses a mathematical formula or some kind of, law of physics, you just have to be careful as a patent drafter to try and leave that stuff out. And focus on the overall system and its design and structure and, really just say that there's some algorithm running in the background that's going to make decisions of what we do and not really get too much into exactly what that is.
Right. Huh.
So basically at the end of the day, I mean, I've heard you go through multiple different trade secrets, trademarks, patents. And the one thing that I think that you said constantly the whole time is documentation and protecting yourself from day one. So that would probably be your most advice to give to anybody. Am I wrong?
No, I think so. I mean, especially with trade secrets and documentation in general for when you're onboarding new people and stuff like that. I think that's tough in a startup. You guys, everything's moving so fast, and people are coming, people are going, and the building's growing, building's shrinking, we're getting new building, it's just, it really is hard to kind of keep up with all of that. And I think that's just the challenge of people running a startup is just, can we get all the paperwork done, in addition to all the daily stuff that we have to get done.
Yeah.
But I think that a lot of people are probably a little nervous to engage with lawyers early on. Whether it was a bad experience in the past or whether they just figure they're too expensive or whether they just assume that, we can only work with the biggest firms downtown, $400, $500 an hour attorneys. But I think that if you just, find someone that you trust and just sit down with them, it doesn't take a tremendous amount of their time or your time to just kind of walk through, like, here's what we're doing.
Right. Are
there any red flags that are jumping out at you? Things like that, because it's so much easier to get ahead of this stuff than try and piece it back together after the fact,
Well, and I think that that's a huge point, Tyler, is, you know, just do business with people that you like. I mean, we have it on our freaking website. You know, it's like if you're likable and you sit down with the guy and the guy wants to, or girl wants to charge you $800 just to listen to your idea, then might not be the right person for you.
Yeah.
You know, and they're probably so busy that they just want you to go away anyways. I mean, we see that all the time where we'll quote something, you know, somebody brings a widget to us to make, and we may not have the perfect manufacturer for it. And we send it over, you know, an RFQ to get it quoted. And instead of just calling us and saying, hey, you know, this really doesn't fit us and the part should cost $50, they quote it and it's $500. You know, and I have to call and I'm like, Jim, just tell me you don't want to make it. Like that's okay. You know, instead of throwing this, we don't want to make a price on it. Just have the conversation with us. And I think that goes so far with so many different businesses, especially with a startup and a new idea that they're not a big conglomerate coming up with a new product and with fresh entrepreneurs is just having a conversation. And if somebody doesn't want to have a conversation with you, then move on and never look back and find somebody that will have a conversation with you. And I think the right person will just be so passionate about helping people that they're going to have a conversation and they're going to guide you and they're going to take, you know, buy me lunch, you know, buy me a cup of coffee and we'll go sit down and talk about it. And, you know, if it's a good idea, then great. If it's not, then, you know, whatever, I got to meet you and we can go on, you know, and I think that that's the fun part about what both of us do is for me, I know it's helping people and, you know, coming, you know, Dan brought an idea to the table shortly after you started here. It was a golf widget, iPower Golf, you know, brand new design. I have no idea. Hell, they may need to talk to you. I don't know, but it's a really cool product. And I think actually Connor, our engineer that we just hired, helped draw it and put I mean, they really came to the table with a design on a napkin and they were making it. The guy was making it in his garage. And I'm like, oh, you know,
he has a design patent.
Oh,
does
okay.
he have it? Okay.
Yeah, he has a design patent.
Okay. I didn't know that.
So,
Interesting. Yeah. But I mean, it's a hell of a
yeah.
product, but
Yeah.
it was fun for us. I'm like, this thing takes off. I mean, it'll be fun for us to be involved in.
Yeah.
And the guy could never get anyone to even talk to him. It was so interesting to me. And I've worked at companies that are like that. They're like, oh, it's a small, you know, there's 100 of those types of widgets out there. I'm like, well, what does it cost you to actually invest 20 minutes in it? You know, and if the person can pay, I mean, if they want to buy 30,000 of them, even though you think it's a shit idea and they can pay for it, let them invest their money however they want.
Yeah.
you know?
I mean, if you think you are so smart
Right.
that you can sit down with someone who just invented a product and he sold
Right.
300 or 400 of them last year, but you're so smart. You already can tell me the trajectory of his business,
Yep.
how much he's going to sell, how much the brand is going to identify with people. You know, even if he remodels it or redesigns it or whatever next year, he won't make money. If you are that smart, you
Right.
should be on Warren Buffett's, you know, payroll, or you should
Right.
be, you know, working
You
for
should
people.
have your own product.
Yes, or you're obviously a billionaire, right? Because you
Right.
can see the future and you invest perfectly.
Right.
And you know exactly. I think it's crazy. I mean, I've seen people come in, you know, to my office and I'll look at the product and to me, I don't get it. You
Right.
know, I don't understand it. I don't know why people buy it. I would never build it myself, maybe,
Right.
but they find a way, you
Right.
know, and what do I know? You
Right.
know, I mean, I don't know this industry. I know my industry.
Right.
And I can tell you, you know, what might happen on the patents and what might happen on this side or whatever, but the world is crazy.
Yeah.
And you just have no idea what's going to be a hit and what's not going to be a hit.
No, and I think you hit the nail on the head. You know, my opinion, I have a horrible taste in dressing. You know, if it was not a T-shirt and some flip flops or whatever, then I want nothing to do with it. And there's, you know, I see people wear things all the time. Especially my daughter, like she wears some. I'm like, oh, is that really fashionable? Like she's like, Dad, have you looked in the mirror lately? And I'm like, yeah, you're right. Wherever, you know, wear whatever you want as long as it, you know, it's respectful. You know, but I go to that because I do think that so many people dismiss and judge, especially with entrepreneurs that have never ever started a company, and they tell you, I mean, I'm sure you were told you were crazy for starting your own firm by somebody.
Sure.
You know, it's like then it just drives you even harder. You know, now I have to succeed. because I don't want that guy to be right or that person to be right. And, you know, same thing, you know, we bit off this, and I had people like, what in the hell are you doing? It's like, I don't know. We'll figure it out, you know, but I don't have anything to prove to you.
Right.
But I kind of do, you know, but I don't know. It is fun. And I think that just with new products, I think is even more fun than, you know, anyone can make a product that has been made for, you know, some sort of legacy item.
Right.
You know, they're fun to have,
Yep.
especially for us. You know, cut us a purchase order for, you know, 1 million of those a year, and we'll make the hell out of them and do really, really good job. But the things that are really fun for us is new product, never been made before. I mean, I've been told there's parts in here that I've been told that there's no way it can be made. I mean, the one part, Dan, behind you, that tusk. No. Well, actually, a part on that, I was told that it was impossible to make.
That's a bold statement.
Impossible. I have an email from somebody. I had that part right there, a tusk. The bends on that, I was told impossible to make.
Wow.
They're both here. They both match the drawing.
They exist.
And I think it's hilarious when people tell me that something is impossible to make. And now I just want to prove them wrong.
Oh,
you know, there's actually a guy that we had on, and we'll get wrapped up here. You know, we've been talking for over an hour now, but one of the guys that is a good buddy of mine, a Phoenicial Fabrication up in Wisconsin that was on, he and I are kind of geared the same. He's a mechanical engineer, worked at Caterpillar on their diesel program, worked at Merck Marine, holds a couple patents, super, super crazy smart guy. And he's the guy that I call, and I'm like, Aaron, I've been told that this can't be done. He's like, send me the drawing. And I'm like, you know, he sent him over the drawing, and he's like, ooh, that's a hard one. And I'm like, do you think you can figure it out? He's like, I don't know, but I'm going to try like hell just because. Yeah. And he did. He's the one that actually made both of those parts.
Wow.
That we were told that was impossible to match the drawing. And it's just, you know, it's people like that will go the extra mile. And his shop, by the way, is probably a 16th of the size of the shop that the guy that told me that it was impossible to make.
Wow.
And it's awesome. Like, I think it's so much fun to be able to go back to that guy and be like, oh, guess what? Well, actually, that part, one of those parts, the guy told me it was impossible. I'm like, well, I have 420 of them sitting on my floor with 2 of those parts per part. Like, so we made, you know, 840 of these things so very successfully. And he's like, well, they're lying to you. Those don't match the drawing. And I walked down to Connor, and I'm like, Connor, do those match the drawing? He's like, exactly. I'm like, all right, case closed, moving on.
Yeah.
You know, so it is fun. But yeah, thank you so much. Why don't you tell everyone how to get in contact with you? I mean, everyone, they know, and we'll put a thing in the description in the bio. You can email us at info@mfgmonkey.com, and we can always put you in touch with Tyler. Tyler, why don't you website, email address, phone number,
Sure,
Snapchat,
yeah,
Periscope, TikTok. Tender ID.
Yeah, put it all on there. Yeah, so just one more time, my name's Tyler Dunham, and my firm's Dunham IP Law, and based in Dublin, Ohio. And you can find us at dunhamiplaw.com. And my email address, if you just want to shoot me an email, is the letter of my first name, T, and then my last name, Dunham, at dunhamiplaw.com. So the best ways to reach out to me. And please, you know, anybody, I do not charge any kind of consultation fees, none of that stuff. Let's just have a phone call. I'm happy to answer your questions and just get you on the right path. And I think just to wrap up, that's the value I think that me and Dustin and all of his team bring you, is that, you know, there's lots of people out there who can make you a billion widgets over and over and over, but someone who can come in and solve the new problems that you have and new issues and stuff that you've never seen before and you're trying to build for the first time or deal with for the first time, that's when we come in. And, you know, we really help with that. And so, you know, I think Dustin would share my feelings in that. You know, a phone call is always productive, whether it's results in business or doesn't. Yeah. It's just a good thing. Yeah, no, and it's a lot of fun, and I know that that's what gets both of us out of bed in the morning. So. That's right, yeah. And a few other things, but all right, man. Leave that for the next podcast, or maybe never. Yeah. But thanks, man. Good to have you on. Yep.